question of Sarah. I don't know, Trish and Karen, where you had time to look at the question, or whether James, you would like to ask them directly to the two. But basically, it was about whether you could say something about public inquiry phase of the JTC 21 draft standards, as mentioned in their newsletter. So that's public, I guess. What does it mean, where and how, if there is any additional information at this point? Many things. Is there anything you can say on that?
I can say from my perspective, Karen and I are involved with a variety of different working groups that are slightly at different stages of what is known as the balloting process. And so that process is a standard process within draft standards making, whereby a working draft, a reasonable working draft of the document gets sent around the various national standards bodies for comment and a review. It's almost like a peer review process. We've had some informal input up until now, but no formal stages in the actual inquiry processes up until now, although we are soon to be embarking on those. So if there is to be a public inquiry, it's quite a way off for that moment, because there will be a variety of different steps we need to go through as part of that national standards body engagement, and also engagement, dare I say, with the European Commission itself, who's been keen to provide feedback to us as well. So I haven't heard too much about any definitive timelines for public inquiry. Karen, have you?
No, and I just want to emphasize that what Trish has been referring to is the national ballot inquiry. So describing it as a public inquiry phase is actually an inaccurate description. It's consultation with your national standards bodies, and you will only have access if you're a member of your national standards body. Now, I'm told informally on the grapevine that there is some process for more general public inquiry at the very end of the process, but I also have anecdotal evidence that apparently nothing has ever changed on the basis of that process. So if you think that that might be an opportunity for changing things, I'm not very optimistic on that one. So it's also, there's no obligation for any change to occur as a result of comments that are produced, simply that they are, like as a matter of administrative law, taken into account. So it's a very good process.
Yeah, so Sarah, if there is anything that yourselves, your team, or the Council of Europe would be interested in thinking about and putting some intervention into the standards, I and Karen and Mila will be more than happy, I can speak for myself anyway, be more than happy to talk to you about some of your concerns and whether or not there's something we can input positively in these earlier processes, rather than wait till potentially some public inquiry later on down the line.
Yeah, thank you very much, Karen and Trish, for these explanations. There are two more questions by Marcel. One has been answered in the chat already by Mila, I think quite sufficiently, but please feel free to add something, Karen and Trish. But the second question, so that's a question on civil society access in the CEN-CENELEC procedure. But maybe the first question briefly on when you talk about consensus-based nature, does it mean all parties involved have to be, okay, I think Mila posted some information, but maybe if you want to, you can elaborate a little bit on that, because I think it could be interesting.
I'll let you, Trish, because you're more experienced with processes than I am.
So it's not an exact science, but the idea being it is not a unanimous vote. That is not what it is. And indeed, in most cases, it's probably not even a majority, because when you're in that room, group dynamics prevail. You have risk of groupthink as well. And in some cases, you have silence. And the question is, how do you interpret that silence? Do you interpret that silence as acquiescence, or do you interpret that silence as objection? So it's very much within the hands of the convener of the particular working group as to how in that moment consensus is interpreted. But consensus is intended to be where there's that overarching overall understanding that the room is aligned in this process, aligned with the text being proposed. If someone has an objection, that if there's one or two voices that are dissenting in the room, they cannot uphold a consensus approach. They can have their objections minuted, and indeed they can also say, I have an objection, I maintain my objection, but I will not stand in the way of this proceeding, if that's the consensus of the room. So you can ask for that to be formally minuted. So there's quite it's quite sophisticated in the sense of it's in the dynamics of the room, but equally it's quite unsophisticated, because there are rules regarding consensus, but there's no real actual guidance for how you interpret that going forward in the room. But they are in our experience, in semi-elect rule books.
So yes, it certainly say one of the frustrating things about this so-called consensus-based decision-making is that it's not over till it's over. So even if there is clear agreed consensus about a particular way of dealing with something or a substantive issue, and that is formally minuted, 4 weeks later, someone may wish to revisit that consensus and challenge that consensus, and the whole thing gets reopened. And I find that really truly astonishing, but nothing is binding until the standards are actually signed off. And there is a process through which, so once this goes to national ballot, it does actually reduce the scope for challenge, because it then only becomes possible to make challenges to the text of the draft or any comments received on that draft. So there's a process of increasing closure that happens over time as the process proceeds throughout its steps. But up until that point, the apple cart can be unseated at any time, literally 12 months after something has been agreed. So I find that truly astonishing. And it's also true, for example, for procedural violations. So as far as I'm concerned, if there's a procedural violation, then there is a set of protocols about what happens. But no, not in this case. It's up to the room to decide whether or not there should be any sanction for anything. So it's truly, in a sense, it's kind of anarchic. And I find that really rather surprising, because nothing gets really stabilized until the whole process has gone right through and has been signed off at the end. So it's an extraordinarily sophisticated but also primitive procedure. At least that's my experience of it. I can't speak for it.
Absolutely. And I will say that whilst we have only observer status as a liaison and have no technical voting rights, we are being respected, at least to be able to have a voice in the room as an individual expert. And I have strategically positioned myself as a BSI Art 1 committee expert, so that I'm in there also as a national standards body independent, so that I do have voting rights in that capacity. So, and also have the ability to comment on document drafts when it's being referenced out to the national standards body mode. So whilst Equinet and others with observer liaison status can comment, it doesn't mean to say that the comments get taken into account.
And I think these are very nice final words for this fireside chat. So I would like to say thank you very much to James, to Trish, and to Karen for this really insightful information. I think